let's talk a little insider baseball. The fact is that even though the cops have a warrant to search or arrest you, that doesn't give them the right to go on some sort of fishing expedition. And I love this recent case. It just came out of the building behind me. Judge Strobridge denied a motion to suppress, and the public defender, Fabian Goffe, did an excellent job on this case. Let me explain what happened. This guy, Gene, is Gene v. State. Gene had an arrest warrant out for ag battery with a firearm. And the cops are staking out his home. They see him ride up on a bike. They have a warrant to arrest him, and they arrest him. Now, he's wearing a backpack. He's wearing a fanny pack. So the first thing the cops do is they take the fanny pack and the backpack, they put it on the hood of their cop car, right? It's like 10 feet away. And then Gene is probably on his stomach on the cement being handcuffed. I mean, they had an arrest warrant. A judge said, go arrest this guy. And that's what they did. Now, the question is, Gene is serving a 3-year prison sentence for possession of a firearm. And that firearm was found in the fanny pack that the cops took from him and put on the hood of their car. This is a locked fanny pack. I didn't know you could lock fanny packs. I don't see why you couldn't. Just never heard of it. But that's what we have here. And the public defender, Fabian Goffe, I don't know him, but wow, what great work. I can see the great work here. Filed a motion to suppress and said, Judge, that firearm that he's now charged with, that he's about to go to prison for, the cops never should have got that because all they had was an arrest warrant. So they don't have the right to search a bunch of stuff that's 8 to 10 feet away from him. The Judge Strobridge, issues a 21-page order denying the motion to suppress. And so Gene enters a plea to 3 years prison with the right to appeal the Judge Strobridge's decision. So what I find great about this case is that this public defender Goffe, after getting a 21-page opinion denying, writes this motion for reconsideration. And I'll read some of it to you. After receiving 21 pages of denial, with all due respect to the court's elaborate and thoughtful order, the court's order illustrates several glaring misconceptions of the applicable law. It goes on, but it's great. Great work from this public defender, Attorney Goffe. And anyway, so it goes up on appeal to the 6th District Court of Appeal. And of course, the 6th District Court of Appeal totally agrees with Goffe, the public defender, and says this firearm that was found in the fanny pack should have been thrown out, because the reason cops get to search you incident to arrest is for safety concerns and for evidentiary concerns. In other words, there might be some evidence or like guns and stuff that would harm the cops, and they need to search your pockets when they arrest you, and they need to search for things on your person. This fanny pack was no longer on his person. It wasn't a safety concern. It was 8 to 10 feet away. He had no chance at it. And the court said, you got to let this go. You have to suppress this evidence. What did they have? They had an arrest warrant. They didn't have a search warrant. They could have gone and got a search warrant, by the way. They could have said, Judge, I think there's evidence in this fanny pack. Well, we wouldn't be having this conversation. But they didn't get a search warrant. They thought they had the right to search the stuff that was now on the hood of a cop car for safety concerns and evidentiary concerns. The appellate court said no way. So great work from this public defender, Fabian Goffe. And this is a great decision, because I think it provides some clarification on just how much the cops get to search once they arrest somebody. It's good stuff.